Very astute of you, Senator Wachowski, but this is B&P. We can add days to months. You know that. So we do have. Is there a motion from Senator Galgiani on the consent calendar as amended? There, please call the roll.
Hill.
Aye.
Hill aye. Bates. Block. Block aye. Gaines. Gaines aye. Galgiani. Galgiani aye. Hernandez. Jackson. Mendoza. Wachowski. Wachowski aye.
The consent calendar has 5 votes. That's enough to get it out. We'll hold the roll open for absent members. And I see Assemblymember Bonta is here. AB 1575, item number 2. Please, make yourself comfortable.
Thank you, Mr. Chair, colleagues. Good afternoon, and pleased to be able to present to you AB 1575 today. And want to start by saying thank you to the committee for your assistance with the bill. We accept the technical amendments that were proposed in the analysis, so thank you for those. And this bill, AB 1575, is a follow-up to the Medical Marijuana Regulation and Safety Act from last year, which was a very comprehensive, groundbreaking approach to regulating the medical cannabis industry and market in the state of California. And we were able to move that bill last year with a number of our authors in both houses working together and working with stakeholders from all over the state to provide input and best practices and put best concepts on the table. And now we need to continue the work and build on it and strengthen it, improve it. And we, of course, have a department now that is moving in the regulating space, passing regs and getting prepared to issue licenses in the near future. But there are also, as we learn more about the implications of our bill from last year, there's additional work to do, and this bill, AB 1575, takes on some of those issues. For one, it allows for research and development of medical cannabis by public universities and private industry alike. It sets standards for the delivery of medical cannabis to patients, making sure that patients are protected and are informed appropriately. It also creates a banking advisory group to help solve one of the most pressing issues in the medical cannabis industry, the lack of access to financial services. It allows businesses to operate explicitly as for-profit, just as they do in other states, so that they are not put at a competitive disadvantage here in California. It also regulates advertising by medical cannabis businesses to reduce black market activity. And finally, it protects manufacturers from state prosecution while we wait for licenses to be issued if the manufacturer is using non-volatile solvents and operating in compliance with their local ordinances and paying their taxes. So it does quite a few things to help strengthen the law around medical cannabis in the state of California. It's an important follow-up to the Medical Marijuana Regulation and Safety Act from last year. We're continuing to work with all stakeholders to strengthen the bill as we move forward, but we think that where we are today makes a significant contribution to what we started last year as a House, and I respectfully ask for your aye vote. Thank you for your consideration.
Thank you, Assemblymember Bonta. We'll take those in support, witnesses in support. If you'd like to sit down, you may. Sure.
Hezekiah Allen on behalf of the California Growers Association. I wanted to applaud the author. As with last year, he and the team of Assembly members have been very open with us, very responsive to all feedback. As he explained, this is a very large bill. It picks up a lot of cleanup pieces from last year. We'd like to thank, I think, the entire state legislature and state government at this point for the tremendous commitments that were made last year through the passage of the MMRSA. The budget trailer process took care of some of the technical procedure pieces, and this is really a fantastic next step in what promises to be a very prolonged effort to transition this industry into regulation. Lots more to work on here. Look forward to working on it. All things considered, it's a great piece of legislation, and we urge your support today. Thank you.
Thank you. This is in support.
Mr. Chairman, members, Paul Smith with the Rural Counties Association, also on behalf of the California State Association and the Urban Counties Caucus, basically representing the county perspective. We have a supportive amended. First, I want to thank the authors of 1575 for the recent amendments that were put in. They took about 2/3 of all of the things that we had asked for as a county family. We still have a few remaining issues to resolve. Those center around the definition of ownership, the R&D research clauses, also dealing with medical privacy. We think we're close to getting there. We encourage this bill to move forward forward, and hopefully we'll resolve all those concerns. Thank you.
Very good. Thank you. Others in support?
Mr. Chair and members, Ivan Altamura on behalf of Certara Therapeutics, and I would just like to echo my colleague, Mr. Smith's comments. We are in a support, if amended, position. We appreciate all the efforts that Assemblymember Bonta has made on this bill. We really think it's a great piece of legislation moving forward, and our only concern is the issue of ownership and definition of ownership and the how we're going to come to a definition of aggregate ownership. What's that right percentage and what's that right balance? But I know that in working with the owners, with the author's office, that's something that is of concern to them that they're going to be working on moving forward. So we're in a supportive amended position, but we really like the direction this is going.
Very good. Thank you. Others in support?
Mr. Chair and members, Rand Martin on behalf of the Consortium Management Group, which operates Caliva, which is one of the largest dispensary operations in Santa Clara County. We have a supportive amendment as well, leaning heavily towards support. We do have had two concerns that we expressed to the committee. One, which we believe your staff has suggested amendments to relative to extraction language and criminal penalties that go along with that. Your staff has shared amendments with us and shared them with the author's office, and we hope by the time the bill is heard in Governance and Finance that he will consider taking that amendment. The second is the one you've heard from several people, and that's the 5% ownership. It really is the tail wagging the dog. We need to find a percentage that actually makes more sense for people who are operating a business, and that's what this is a business. We urge you to consider some way to fix that, and otherwise we think it's a great bill. Thank you.
Very good. Thank you. Others in support?
Mr. Chair and members of the committee, Viviana Becerra on behalf of the California Cannabis Operators League and CalCan Holdings in support. We thank the author for carrying this measure and for also putting a provision on illegal advertising. All that we would ask is if we could continue working with the author to really raise the penalties. Right now there's a $500 fee if you are a business operating illegally and advertising. We'd like to see those a little more stronger, but in all, we support the bill. So thank you.
Very good. Thank you very much. Others in support?
I'm Karen Leggett, and I am in support of this because it will regulate them even more so, pay taxes, and hopefully protect our children. That's my number one priority, is protect our kids. So I am in support of his bill so far.
That's good. Thank you,
Thank
Ms.
you.
Liggett. Appreciate it. Thank you for coming today. Others in support? Seeing and hearing no one, is there anyone here in opposition? Please come forward. Yes, sir. Make yourself comfortable.
Mr. Chair and members, I'm opposed unless amended to this bill. The reason is because it unconstitutionally affects the immunities provided in the initiative. I draw your attention to page 55, line 27. It's a section D, and page 58, line 28, subsection G. The issue here is that back in 2004, Vasconcelos was required to place limitations on patients' possession and cultivation. It took 6 years through the courts, but in 2010, the California Supreme Court struck down those limitations. I was amicus curiae to a unanimous Supreme Court decision Ron George wrote. The situation today is that the 100 square foot limitation that's expressed here is a compromise to the patient's immunities. It's insufficient and it's unconstitutional under Kelly. The decision was People v. Kelly, 47 Cal 4th, page 1008. On page 1012, you'll see my name as amicus curiae. So that's the one problem, is the 100 square feet is insufficient and it violates Kelly. It violates the patient's immunities. We need to enlarge that number. I'm suggesting 250 square feet for various reasons. 200 square feet is now the practice in Berkeley. And the second problem is that the abolishment of collectives is a tricky issue, but it's a serious issue. The problem is that dispensaries and collectives have been, unfortunately, conflated. I've inquired to the Legislative Analyst's Office, and they agree with me that they have erroneously conflated dispensaries, storefront dispensaries, with collectives per se. It's as if every 5 or 20 patients that want to group together and associate to provide access for themselves are a storefront dispensary. And of course, that's not the case. And I think you'll find a lot of these groups around the state don't have a lot of lobbying power. Every 5 or 20 patients out in the landscape, they're not organized to come here to express what I'm expressing to you today. And that's that both of those facets of the new state program, the limitation of 100 square feet and the abolition of collectives per se, are unconstitutional under People v. Kelly. I have alleged council amendments that are intended to resolve this. I'm still working on perfecting those amendments, so I can't offer them to you today. But I would encourage you to, I'm supportive of this bill moving forward and these issues being percolated through the committees that it's going to be seeing. And I'm rather confident that before the end of the trail, we'll find some relief.
Very good. Thank you very much.
If you have any questions, I'm happy to respond.
And I guess my first one would, so we could look for your name in the amicus briefs. What is your name?
Robert E. Harris.
Robert E.
Is how
Thank
it's
you, Mr.
listed
Harris.
as. Bobby Harris is how I'm known around the Capitol here.
All right. Thank you, Mr. Harris. I appreciate it very, very much. Thank you. Others in opposition or support if amended? See no one. Bringing it back to the committee for. Oh, yes, Senator Wachowski.
So I guess the first question would follow up on Mr. Harris. I'm reading subsection G on page 58, and it does appear that we're going to limit the cultivation acre or space to 100 square feet. What's the state's overriding interest over the cultivated space that people use now? 250 or 300, whatever it is.
No, thank you. Good question, of course, and just a couple clarifying remarks first on the points raised by Mr. Harris. First, neither of those issues are being proposed by this bill, AB 1575. They are an existing law that was passed last year and signed by the governor. Those were part of the Medical Marijuana Regulation and Safety Act. So we're not proposing 100 square feet limitation. It's the current law. We're not proposing a rollback of collectives in favor of a licensed regulated market. That's the current law. So just to be absolutely clear on that. And on his comment about criminal prosecution, there is no change to immunity on the criminal prosecution side. That's what the constitutional provision was, the Compassionate Use Act back in 1996, and it's not changed. This bill, last year's Medical Marijuana Regulation and Safety Act and this year's bill do provide civil regulation. And of course, that's very different than providing criminal liability. So we think it's important to provide a space for personal use. We think the 100 square foot limitation, based on all the stakeholder input that we had last year, that's how we got that amount and put it into the bill last year. We had patients at the table. We had local governments at the table. We had industry. We had unions. We had public safety folks there. And that was sort of where we ended up with all the input.
Right. I mean, I guess his claim is that it's unconstitutional because of the, 1,000-page decision that came in. I guess we can always change the law, no matter what the courts say. I guess the other question I had is on the 5% ownership. I was struck by that as what's the basis of the new definition? And I guess I should ask, what was the old definition that we're fixing?
This has been something that we've been spending a lot of time on, and we're trying to get it right. I think there will be more discussions. We did have a 5% threshold for public corporations and businesses, and there was no limit at all on private companies. And so the 5% came out of what we had been previously using on the public side. Are we rigid in sticking with 5%? Absolutely not. We hear the concerns. We want to do what we've always done in crafting our medical cannabis laws, which is receive all the input and try to make it work.
what are we worried about if somebody holds a 20% interest in a private dispensary? What's the state's concern that's the harm, I guess?
We have right now the 5% is a minimum. So once you have a 5% ownership interest or above,
right,
then you are considered an applicant, and you need to do the background check, and you need to comply with all of the suitability requirements that are in the law. We have some restrictions on how many different licenses you can have and which ones you can have in combination with one another. Some licenses, you can only have that license and that license only. Other licenses you can have in different combinations with some restrictions. So we're trying to protect against illegal cross-licensure by tracking the ownership interests of the applicants.
No, I know one of the concerns I had last year is this articulated concern about people who have criminal records. And, I just think that all the people that have been selling cannabis and have been in the cannabis business and understand the differences and the strengths, and that's a huge wealth of information. The people that are professionals in there, but for this criminal conviction when it was illegal. And I didn't always agree with the authors last year on the path that you took. And it seems that this 5% might be another exclusion of folks who really know this area of commerce. So I'm glad that you're looking at that. On page 7 of our analysis, the requirement that the person who delivers only contract with one dispensary, I'm trying to think of in rural areas where somebody, again, why would I care if somebody works for 2 dispensaries if they're a delivery person? As long as the locals know they've got their license, you got 4 or 5 things that they have to do. Because I read it as a prohibition.
Interesting point that, and thank you for your comments on numerous points, Senator Wachowski. And on the delivery thing, or the delivery piece, we think it's important that there be one representative from one dispensary that's able to represent that dispensary's products without any cross-pollination, so to speak, of the different products from different dispensaries. We've added language that requires the deliverer, the person doing the delivery, to have a good command of the different medicines that they're providing to the patients. That's a patient protection item. So we think with the exclusivity, it will allow for better patient protection and safer representation of the products.
Because, I'm thinking of the person that sells Coca-Cola versus the person that sells Pepsi-Cola. And I'm the guy in the car. And I can have both of them and understand the differences between them. If I have a dispensary that has this type of cannabis and this one that has this type, and they are for different ailments and different age groups and affect people differently, why that would be adverse to the consumer, that we only have one. So I appreciate you looking at that. I know we want to regulate in this area. I was struck by page 5 of all the different licensees now. I mean, a lot of people complain about government. So we're saying if you got a license 6 and 7, now you're able to have a type 10A. If you have a 1 and 2, you could have a 6. It's I know what you're trying to do here is to make it easier, more elastic. Sometimes it reads like we're letting the bureaucrats run wild in our zeal to control or have a licensure on cannabis. And I guess I'm old-fashioned. People have been trading pot and using it for years, and it doesn't seem to be a big problem. I don't see the outcry from the consumer in just my casual intersection with them. So good luck with the bill. I'm I hope that we're not over-regulating in this area in our desire to have medical marijuana dispensaries set up. But that's all I have. Mr. Co-Chair.
Yes, Senator Jackson.
Yes, this may be a naive question, but what happens if in November one or more of these initiatives is passed? How is your bill, how is this sort of protocol or infrastructure, how is that going to be impacted? I mean, are we here and are you working hard at creating something that in November will be impacted by the initiative process, should the will of the people be such?
Our bill and the proposition work in two distinct spaces from one another. Ours regulates what has already been legal in California since 1996 with the Compassionate Use Act, Prop 215, the medical cannabis space. I think the one proposition that we're most likely to see on the ballot deals with adult use. So other folks call it recreational, not medical cannabis per se. We have looked, of course, at the language in the Adult Medical Marijuana Use Act, and there's a lot of similarities. I think a lot of our language was used to inform the proposition. There are some distinct differences, and the writers of the proposition, when there were differences in how they will be treating adult use cannabis, had a different policy view than we did. So this work will continue to be important. It will continue to regulate the medical cannabis space. The only question is, will there be some different rules that apply to adult use than what we've crafted in the legislature through medical in the medical cannabis space?
So if you'd pardon my naivete, the medical cannabis industry, some would say, was a way to get cannabis into public use as sort of a precursor to the adult use of cannabis, or whatever we want to call it, to legalization of cannabis. I mean, if cannabis is legalized for recreational use, what reason would we have to continue with medical cannabis? I mean, I think part of this has been for years just a way to try to address what is for some a drug and some a recreational product, or whatever you want to call it. And now we're going to see an initiative that may very well pass, let's assume it does just for purposes of discussion, that says that adults can use cannabis. You can buy it, we're going to regulate it, we'll legalize it, regulate it, tax it, whatever they're going to do. And what happens to the medical cannabis industry? Does it essentially go away? Or let me put it this way, why should it continue?
Great question, obviously, and something that other states have dealt with and are dealing with that have already passed propositions on adult use. We don't know what the future will hold, but because we can't and don't, we need to operate with the facts that are in front of us. Right now, we have medical cannabis that's legal in the state, and medical cannabis only. Maybe the proposition will pass, and if so, then I think we're going to be doing some reconciliation next year, looking at what has passed and what we've done as a legislature and trying to create a system that works. Adult use, of course, is adult use for adults. We do have users of medicine, of medical cannabis, who are not adults, who are kids, who cannot just buy on the recreational market. That would need to have a doctor's recommendation for use. So there are still spaces where medical cannabis, regardless of what happens in November, will be an important source of medicine for patients in need.
So other than that, if I may, one last question, because I really would like to get a sense about what is going to happen to the medical cannabis industry if we have a proposition that legalizes marijuana or cannabis. Right? What's going to, is medical cannabis, other than for people under the legal age, is there going to be any other function for medical cannabis? Because you're working so hard at creating this structure, I'm wondering, is it really, Is this something in anticipation that that the initiative will pass or won't pass? I mean, if it doesn't pass, then it's still illegal. But if it does pass, where does medical cannabis stand vis-a-vis the initiative? And now suddenly recreational cannabis is going to be available to adults.
Right. A couple answers to your question, and it's a great question. The first one is, I think it's very important that the legislature play a leading role in the crafting of the laws around medical cannabis. And we did that last year. We had a bill, of course, that was signed into law. It was there for all to see. Certainly, that work, which was informed by the deep stakeholder process that I discussed earlier with stakeholders from all over the state, from all the different industries, with legislators working in both houses together, that kind of work can't be done in a proposition. So it was important work to do. It was work that was unique to the legislature to be able to do, and that work informed the proposition. Again, a lot of what we designed through the Medical Marijuana Regulation and Safety Act is in the proposition. So whatever happens with the proposition, even if it passes and there is some sort of pressure on the medical cannabis market, our work would have been very valuable. We can look at other states and see what's happening. There is definitely tension in states where there's medical cannabis and adult use that are both legal. I think that many businesses will want to only get one license if they can. So that's what next year will be about. If we get a proposition that passes, we will do reconciliation. We will try to create a process that works. I think there still will be a space for medical cannabis. It might shrink. There might be pressures on it if adult use passes, but I'm not prepared to say, one, that the proposition will pass, or two, that its passage means the end of the need for medical cannabis in California.
Thank you.
Is there a motion?
I'll move the bill.
And then would you like to close, Assemblymember Bonta?
Thank you for your consideration. I really appreciate the very close look by members of the committee into the bill and the discussion and the questions. I really appreciate it. I just did want to mention one thing to Senator Wachowski, since you read the bill so closely and you were raising some concerns and interest on the issue of the different types of licenses. That was really asked for and designed by with the input of the industry, and it was a way to do certain things like when you can only have one license for a testing license, make sure that testing is independent and not unbiased, and make sure that we protect the product. So I know when you look at it, it seems like there's these different combinations that seem like it's too much administration and regulating, but there's real important policy reasons behind each of them for patient safety and health and for other reasons. But I really appreciate the discussion. Thanks again to the committee. Thank you to the chair and members. Respectfully ask for your aye vote.
Thank you. Just a comment. I'm sorry I missed the early part of it. I think there's parts of the bill that are really moving in the right direction. I'm going to lay off today. I do think you need to take these concerns and kind of work a little more on it. So we'll have our Madam Secretary call the roll.
Okay, motion is due pass as amended to Governance and Finance Committee. Hill? Bates? Block? Aye. Block aye. Gaines? No. Gaines no. Galgiani? Hernandez? Jackson? Aye. Jackson aye. Mendoza? Aye. Mendoza aye. Wachowski? Aye. Wachowski aye.
Vote is 4-1. We'll hold it open until the rest of the members are here.
Thank you, Madam Chair, colleagues, and staff.
Next, author AB 2179, Assemblymember Gibson. Welcome.
Thank you very much, Madam Chair and Senators. Thank you for allowing me to present Assembly Bill 2179, which seeks to give local government greater flexibility on reducing costs related to training of non-medical personnel to administer the rapid test for hepatitis C in community settings. I would like to start off by accepting the committee amendments and thank the chair and the committee for working closely with my team in order to making this bill a better bill. Currently, training is centralized at the state level and requires non-medical personnel who wants to offer hepatitis C testing to also be trained to provide HIV testing. Community-based organizations that are willing to provide hepatitis C testing often experience challenges in the training their staff because of the long wait time to receive both trainings, which can be somewhere from 6 to 18 months. In addition, HIV training is unnecessary for hepatitis C testing counselors working with organizations that do not provide HIV training. This bill will decentralize training for hepatitis C testing counselors by allowing the county public health department to certify training standards for rapid testing counselors and streamline the testing process. With the cure of hepatitis C now a reality, there are more resources going towards testing and more people needing to be tested and certified. Expanding access to certifications for hepatitis C testing will improve awareness of hepatitis C status and reduce regional and income-based disparities. Here with me to provide supporting testimony is a representative for Project Inform.
Move the bill.
Thank you. The motion. Go ahead.
Good afternoon, Chairwoman and Senators. Thank you. My name is Emily Hirio, and my organization, Project Inform, is the sponsor of AB 2179, which would allow local health departments as well as the State Department of Public Health to certify training standards for hepatitis C test counselors. And as you know, CLIA waive tests, which this test is, are easy to use, low risk tests that meet the federal requirements for waiver under the Clinical Laboratory Improvement Amendments Act of 1988. So as was mentioned, this bill would remove the prerequisite that non-medical personnel performing hepatitis C testing first be trained as HIV rapid test counselors. We interviewed a number of community programs around the state that identified significant barriers to screening at-risk populations for hepatitis C, and one of the barriers they identified was that even when programs have funding to do hepatitis C testing and the staff that are needed and they can purchase test kits, they can't access a hepatitis C specific training in their jurisdiction, and they can't afford to send their staff to a joint HIV Hep C test counselor training that's usually held in the Bay Area or LA. There's 4 to 5 times more Hep C in California than HIV, but current law ties the training of test counselors to HIV. And hepatitis C is also more geographically dispersed than HIV. It's more rural and suburban and less urban, though certainly exists in many urban communities as well. So for those reasons, we sponsored this legislation and are pleased to answer any questions you might have.
Are there additional witnesses in support?
Roberts. I'm here on behalf of the Health Officers Association of California. We're in support. Thank you. Thank you.
Witnesses in opposition? There are none. Committee questions? There are none. We have a
Thank you very much, Senators and Chairwoman. Thank you very much for allowing me to present this bill, and certainly respectfully ask for an aye vote. Thank you.
We have a motion from Senator Gaines. Ask the Madam Secretary to call the roll.
Very good. Thank you.
Motion is due pass as amended to Senate Health. Hill?
Aye.
Hill, aye. Bates?
Aye.
Bates, aye. Block?
Aye.
Block, aye. Gaines?
Aye.
Gaines, aye. Galgiani? Hernandez? Hernandez, aye. Jackson? Jackson, aye. Mendoza? Mendoza, aye. Wachowski? Wachowski, aye.
Bill has 8 votes. We'll hold the roll open for absent members. Thank you.
Thank you very much, Senators.
We'll move to item number 5, AB 2307.
Good. Thank you.